Yours is on?
Yeah, I can see Lisa Hobbs on.
All right. Ms. Hooks said that her feed for YouTube is now hot, and she can see Ms. If it makes a difference too, she can see Ms. Hobbs on her screen. Yours is on?
Yeah.
All right. I had one staff report in that they could see it. And so now we will give Council Hobbs, if you can confirm that your client or co-counsel is able to see it now, that'd be great.
Yeah, I just texted him again, Chief, and he is, I see the little dots that he's replying, so let's see what he says. I told him to try refreshing the feed too.
I'm trying to pull up the YouTube feed on my iPhone and it's not coming up.
I've reconnected it. It should be, and I have the logo on my screen here that indicates that it is live. And I've got a report in from one of John's staff counsel that they can see us now. Do you all have the logo in your upper left-hand corner that you're live on YouTube? Okay. And it may just be a delay in because it's not real time on the live feed. There is a delay, sometimes of a number of seconds. It's not like this. But if Ms. Hobbs, do you have any information from your client yet or co-counsel?
I don't yet. I just sent him another text, Chief.
It's up.
It's up?
It's up, Your Honor.
Okay.
I'm going to stop the live feed.
All right, it shouldn't be circling back now. If it starts that, I'll have a whole nother problem, but I think I'm good. If you've seen one of the Supreme Court oral arguments, you know that this is not it. Ours is very different. We are, if I could get everybody to turn their microphones off now so that we don't get any feedback, that would be great. If you've seen one of theirs, you know that they use a virtual background. Obviously, we are not doing that. They do robes. Obviously, we're not doing that. They do a formal call off with Blake Hawthorne at the beginning of the session, and our clerk was prepared to do that, but I told Nita that would be okay, that wouldn't be required. We tried to set this up where we were all three judges in the same room with the clerk. Specifically, we were going to try the courtroom. Technical issues overwhelmed us. You can tell we have no technical guru here on staff. And so it was just a host of problems. And that was before we even connected to the live stream. So, and the reason I'm telling all y'all this is this is not going to be smooth. I do not want y'all to be concerned about the presentation. I don't want you to be nervous like I am about the technical side of it. Just relax and we'll get there. I do ask that to the extent possible, you avoid the distractions. The fact that none of you have a window in the background is great. We've tried to mute our telephones and cell phones and that kind of stuff, and would ask y'all to do the same. And if you mute both your phone and turn off your camera, what it does is it takes you off the view of the live stream as well, makes everyone larger. Before COVID-19, we were audio recording oral arguments. I know Council Jefferson had been at least to one of those. We'd recorded it and then posted it to our TAMES case management system so that the public could do it. This is a little different because it's being both audio and video recorded on the YouTube channel. It will stay there. We are not planning on deleting that, but we do reserve the right for whatever reason to delink it or delete it. One difference may be that these two arguments may forever be linked in that tape or in that feed on the case management system, because we'll just link it and both will be there. We did provide the YouTube channel URL to two professors, the ones at Blinn and at Sam Houston State. Traditionally, we go down to each school, one in the spring, Sam Houston, one in the fall, being Blinn College. And we had to cancel our spring trip to Sam Houston. We had to cancel our fall trip to Blinn, and this is a test run for another meeting at probably in early November for a substitute. But they were both very excited to see the type arguments that we selected for this our maiden voyage test run of this method of doing oral argument. What we are interested in as the judges is understanding the issues, and so rigid adherence to the time allotted you can give us back time, but if we are engaged in a meaningful discussion when the time runs out, and by the way, I get to determine that as to whether or not it's meaningful. At that point, you'll just see more time added to the clock. And that's the way that I handle that. But it is the basic green, yellow, red. But when the light is illuminated, you cannot read the words behind it. You know, that's the technology that I'm limited to. I do anticipate that we'll go straight through both cases, but if either of the judges at the in between the two cases needs a break, then we'll take one at that time. Won't be more than just a few minutes. Normally at this time, I would turn to my colleagues, literally left and right, and ask if there's anything that I forgot. And I see in my notes, there is one for sure. This is the first time we've done this. I know that there are folks on this call or on this hearing that have far more experience at doing these than I do, or than we do. And so we ask for your feedback, whether you are on the YouTube channel or one of the four attorneys here. We want your feedback. By no means should anything I've said be an invitation to ex parte communications about the merits of the litigation. And I know we've got fine counsel here, and that's not going to happen. But if there's something about the method by which we did it that can be improved, you know, we're all learning, and nothing, just because these are our first, by no means should that be taken as anything that this is not real oral arguments. I mean, I know that we take this very seriously, just like y'all, and we scheduled these cases because we had issues that we wanted to talk to you all about, not just because, you know, they were the ones that were next to be done or something that we have issues that we do want to talk to you all about. With that said, I turn to my colleagues and is there anything that we had talked about at pre-sub or in discussion that I have not covered with council?
Tom, you're fixing to call the docket, but in addition to that, when we get to the end, you might have to figure out how we're either going to get supplemental or letter briefing from the attorneys when we're finished with the particular arguments.
Okay.
That's the only thing I have.
John, anything?
Nothing else.
Okay. Attorneys, are there any issues kind of unrelated to more to the procedure that you want to comment on at this point? Okay. All right. I'm going to call the docket. We were provided oral argument exhibits by at least one party in each of the proceedings. Have these documents been provided to opposing counsel? Okay, opposing counsel, are there any objections to them using those documents during the course of oral arguments?
No, Your Honor.
Okay. Then the court calls, and I may mispronounce the name, Somm versus City of College Station. Wallace Jefferson, are you ready on behalf of Ms. Somm?
Yes, Your Honor.
And Ms. Killian, are you ready on behalf of the City of College Station?
Yes, Your Honor.
Okay. The next case on the docket will be In Re Metropolitan Water, an original proceeding. Mr. Counsel DuBose, are you ready on behalf of Met Water?
Yes, Your Honor.
And Ms. Hobbs, are you ready on behalf of, I think it's the respondents, the real party in interest, excuse me.
Yes, Your Honor, we're ready.
Okay. At this time, Counsel Wallace Jefferson, representing the appellant in Somm versus City of College Station, you may begin.
Thank you, Mr. Chief Justice, and may it please the court. The offerer in this case, Jerry Somm, is the master of her offer. It is her land, and so she had the absolute power to sell it only on her terms. One of those terms was that the contract be fully executed. The city felt the same way. It refused to purchase the land unless the contract was first fully executed. That's their words. Both sides wanted all signatures on the agreement as a condition to the deal. And the signature condition is in the contract itself. Jerry Somm required, as a precondition to selling her land, that the mayor execute the contract, quote, on behalf of the city, unquote. And if the court will permit, I would like to walk through the contract. It will take just a few minutes. It's at tab 2 of our oral argument exhibits. As you'll see at the top of the contract, this is a real estate contract. The sale was subject to city council approval. And how did the contract say that approval would manifest? Quote, by signature of buyer's representatives to this contract. That's on page 1 of the contract, clause 1.1. And the very first representative directed to sign for the city, it's the mayor, which is directly below the execution portion at the end of the contract. So long before Jerry signified her offer to sell, she knew that the sale would not occur unless the mayor signed the contract. And we know at page 4, it's clause 5.1, that the parties demanded full execution of the contract because the date of closing was conditioned on full execution 120 days later. We know from page 7 that the persons executing the contract were acting in the capacities shown in the signature block. The mayor signed as the buyer. The city manager signed as the approver. If this contract had been fully executed, it would have been natural for Jerry to say, I sold my land to the buyer. It would be nonsensical for her to say, I sold my land to the approver. Clause 9.10 permitted the contract to be executed in identical counterparts, again, contemplating signatures. Only one person in the entire contract signed before a notary public, and that was the mayor. And he acknowledged that his signature was, quote, on behalf of, unquote, the city of College Station. The signatures were thus a condition of mutual assent. We also know this because 4 times over 3 years, and you'll see this in tab 1 of our oral argument exhibits, the city compelled SOM to agree that the party's legal obligation will arise only from a fully executed contract. And that did not occur here. And
Now,
so
I need to ask you about how this fits into the elements of a temporary injunction and the standard of review for the temporary injunction versus what we might see if this was a motion for summary judgment or a post-jury trial. Because is there a fact question about whether or not they agreed that the mayor's signature was required first? And is this a question of law determination, or is there a fact question?
thank you, Your Honor. So you're right, this is a temporary injunction. A temporary injunction is an extraordinary remedy because it orders someone to do something that she has a legal right to do. The standard, you asked about the standard. A temporary injunction requires proof of a probable right to the relief sought. And if that is unavailable as a matter of law, the temporary injunction cannot issue. On facts, the relevant facts here are completely undisputed. There is no evidence supporting the trial court's finding that the city has established a right to relief. And we ought to look at the trial court's ruling, and it held in the temporary injunction order that a valid and enforceable contract was formed on September 11th when the city council approved the contract. But that is a legal conclusion and it is wrong. And the trial court has no discretion to get the law wrong when it is clearly stated by the Supreme Court statutes, Constitution, or other applicable law.
And it's your position that that is not subject to a factual determination that there may or may not have been an agreement that this mayor had to sign before it was fully executed?
I don't think that there is any fact dispute on that question. And the contract has the conditions right there within the 4 corners. The court can decide this case based on the contract alone. If the court wants to look at the underlying facts that gave rise to this contract, it can do so because all of those facts support our argument here that the contract required the mayor's signature as a condition for its validity.
But as a temporary injunction hearing, we can't get to the merits, but it sounds like you're arguing that this is one of those cases in temporary injunction law that you can't get to the temporary injunction holding or ruling review of without deciding the merits.
I think that's right, Your Honor, and it's also the most prudent course here because they are intertwined. The question is, has the city established a right of a probable relief? And if the answer is emphatically no, because Jerry Somm revoked her consent before the contract was fully executed, then the court can declare that. It doesn't mean the case ends. It would be remanded back down to the trial court for additional proceedings, and that's what we've asked for in our prayer. But I agree with you very much that that legal determination should decide almost every issue in the case. There are pending claims that are still down at the trial court, and so the parties would have to go back down to work those out.
Okay.
And so that's part one. It was not fully executed. It wasn't executed at all because of the mayor's absence of the signature. The other issue is that it was never delivered, which is another contractual requirement before you can enforce a contract like this. So let's think about the timeline. On August 23rd, 2017, after about 3 years of negotiations, Jerry Somm returned the signed contract to the city. And then the city council had a meeting on September 11th in which the city council met and purportedly approved the contract. Now, if you look at what was on the agenda, approval didn't mean that the contract was approved formally. It just means it was considered by the council. On September 12th, the day after the city council meeting, that's when the city manager and her assistant signed. And on September 13th, the next day, Jerry Somm revoked the contract. And finally, on September 14, after the revocation, that's when the mayor signed and the city secretary attested. Now, the primary argument that I want to make here is established by the Supreme Court of Texas, by Corbin on contracts, by the restatement, all of which we have cited to the court, that the offerer is the master of her offer. So she has land, and it was her land. She could dictate the terms of her offer to sell. She could have conditioned her assent to sell that land by not only requiring the mayor to sign, but if she wanted to, the entire city council. She could have refused to sell unless the governor of Texas signed the contract. If any of those conditions were not acceptable to the city, it could have walked away, or it could have made a counteroffer. What the city could not do is purport to execute a contract in a manner that Somm never consented to. So here, she demanded, and in fact, the city also demanded, that the mayor's signature was a necessary condition to enforcement of the contract. And for this reason, it does not matter whether the mayor was authorized to sign the contract on behalf of the city, although the evidence is crystal clear that he had that authority in his testimony and the city council's own resolutions. But if the city were right that only the council or the mayor, city manager could execute a contract and that the mayor could not do so, it would confirm Somm's argument here that there was no meeting of the minds with respect to execution and therefore no contract because the terms clearly required the mayor's signature. Now the city says, the mayor has no authority to sign contracts on behalf of the city. Again, I think this is a legal question. It's not a fact question. Legally, the city council had a resolution, the same one that gave the city manager authority to sign with council approval. And that resolution says the mayor can still, quote, I'm quoting from the resolution, execute contracts on behalf of the city when the city council has duly approved such contracts if required by law or as a condition of the contract. Here, the city's language said the mayor's signature is a condition of the contract. The city council resolution therefore gave its agent, the mayor of College Station, the authority to sign, and the contract explicitly required the mayor's signature right below the statement saying that it was executed in September, and the mayor signed on behalf of the buyer. The mayor testified unequivocally that the council had authorized him to sign that contract, and so he was obligated by council vote to sign the contract. Now, look at this in relation to what the city manager did. And the contract, again, on tab 2, under his signature appears under the term approved. It's a bureaucratic letter or term. So he merely approved rather than executed the contract. So it is not relevant at all to this proceeding in our view that the city manager approved a contract before Jerry Somm revoked her consent. The next thing that the city says is, we can't execute a contract by signing. And again, the law is completely to the contrary. Cities regularly execute contracts by signing them. And the Supreme Court of Texas as early as 1883 in the City of Galveston case that we cited to the court, held that a contract, quote, may be made by the city council direct or by agents appointed by the council with the power to act. Here, the mayor was an agent appointed by the council with the power to act. And just a few years ago, this principle was reaffirmed in City of Houston versus Williams. There, the contract, quote, was signed by the mayor of the city, who appears to have been duly authorized to do so, and therefore it was properly executed. So the city here, it drafted the contract to be executed by the mayor as the buyer on behalf of the city. So of course, the mayor has been granted the authority by the city to contract for the city. College Station empowered the mayor, its agent, to sign this contract. Now, there's a case I think is very important for the court's consideration. It's a 1955 Supreme Court of Texas case, authored by then Justice Calvert. He later became Chief Justice. It's the Simmons Construction Company versus Ray case. I'm pronouncing it Ray, it's spelled R-E-A. There, Ray was the general contractor. It had a contract for improvements to an Air Force base, but much of the work was to be done through subcontractors. So Simmons bid for the electrical work as the subcontractor. They had an oral discussion about potential terms for the work. And then the parties agreed on essential terms of the subcontract. Ray reduced the agreement to writing, just like the city reduced this contract to writing. It was a formal contract. It required a bond within 5 days from the date of signing, just like ours requires action to be taken 120 days from the date of signing. It concluded that in witness hereof, the parties have executed this agreement, and beneath that were places for the parties to sign. Simmons signed the documents, got the bond, and mailed the contract to the general contractor. 3 days later, the general contractor, Ray, returned the contract unsigned and said it could not enter into contractual agreement. The question presented was this: did the parties intend that signing was a condition preceding to its becoming effective as a contract? That's how the Supreme Court phrased that issue. And the court answered the question, yes. And it based its holding on the following: that the general contractor incorporated terms into a formal written instrument, just as the city did here. Number two, that the instrument not only expressly provided places for signatures of both parties, but expressly provided places also for the parties to swear to it. Here, same thing. Signature requirements, and the mayor had to swear to acknowledge that it was his signature. The general contractor required the subcontractor to return the document for signing. Same thing here. So the court held the general contractor, Ray, intended that the written instrument must be signed by the parties as a condition of his assent. There was no evidence that the general contractor waived the signing as a condition preceding, and there was no acceptance of the contract by Ray after Simmons had signed, and there was no acceptance before of any benefits under that writing. Now, here's the quote that I think is important that the Supreme Court said. It is the undoubted rule that where the contract contemplates the execution of it by signing, either party has the right to insist upon the condition, and mere acts of performance on the part of one who has not signed will not validate the contract. And so here, Jerry Somm, the master of her offer, required the mayor's signature before the contract could have any effect whatsoever. And she revoked her consent before the contract was fully executed. It is this, yes.
Talk to me about the statute of limitations, and is that a red herring in the process, or the city wants to argue, as you've seen in their brief, that it's binding on Ms. Somm whether they signed it or not?
Thank you for that question, Chief. I think the city has not understood our argument. Maybe we weren't as clear as we could have been, but here's the thing. Somm is not arguing that enforcing the contract against her would violate the statute of fraud. That is what they think that's what we're arguing. That's not what we're arguing. This is the important part about the statute of frauds. The city's premise that it could execute the contract itself without signing would create real estate contracts that could be enforced only by the city and not by their contracting parties. And that's not what the law is, and that's not what our agreement provides. SOM did not, there's nothing you will see in the contract or in any of the negotiations where SOM gave the city a unilateral right to enforce a multi-million-dollar real estate contract. Her offer was premised on a contract that required bilateral signatures, permitting mutual enforcement. That's the argument that we make about the statute of frauds.
Okay.
And so,
Counselor, if you don't mind, refer back to the real estate contract and direct me to the language where SOM is requiring the mayor to sign the contract in order for it to be valid.
yes, Your Honor, it is just like,
The contract,
sent,
you did that initially.
I'm sorry?
I said you did that earlier, I know, but I didn't have the contract in front of me when you went over that initially.
Okay, so if you'll turn to, once again, to tab 2. And there, that's the real estate contract, subject to city council approval. Now, how did the contract say approval would manifest? Quote, by signature of buyer's representative to this contract. That's on the clause 1.1 at the end of that paragraph. Okay, so that's the first point. And then the very first representative who is directed to sign on behalf of the city is on page 8 of the contract, and that is the buyer represented by the mayor, Carl Mooney, mayor, who signed it on September 14. And so our point is, long before Jerry signified her offer to sell, she knew that the sale would be contingent on the mayor's signature. We also know on page 4, at 5.1, clause 5.1, that the parties demanded full execution of the contract. That means all signatures had to happen because the date of closing was conditioned on full execution 120 days later. And on page 7, we know that the persons executing the contract were acting in their capacity shown in the signature block. And that was my point earlier. The mayor signed as the buyer, the city manager signed only as approver. And that's why I was making the point that it would be unnatural for anyone to say that I sold my land to the approver. No, it's to the buyer, it's to the city.
Counsel.
And finally, I would say, as my time is expiring, I want to answer any questions the court has, but it is also completely undisputed that delivery never occurred here. And we cited a case from this court that recognized that, quote, this is a quote from this court in 2004, delivery is a requisite to the existence of a valid enforceable contract. That's in the Baylor University case. And here it's undisputed that no one from the city ever notified SOM that the city had accepted or executed the agreement. The city's agent tries to reverse the obligations here. But that doesn't work. They try to make SOM have to monitor daily what the city is doing in order to inform herself on whether, today or tomorrow the court will have accepted the contract. And that is not how it works. And here the city's agent testified that the city was obligated to communicate its acceptance directly to SOM and that there was nothing that stopped them from doing it here. In fact, in the contract, any notification, there's a provision about how to notify a party of anything that is required to disclose, and that was by US mail. The mayor admitted in testimony that SOM needs to know the city of College Station has agreed to be bound by the terms of the contract. So this argument that SOM had an affirmative obligation to determine whether the city accepted the offer is not consistent with the law. The law places the burden on the offeree, and nothing permits the offeree to shift that burden.
Counsel,
the
you
state-
may have addressed this, and don't worry about the time. I know Rex had a question, and we'll get to that too. But I don't remember if it was you or the city that referred to the actual agenda item and the vote. And the reason I bring this up is in light of the argument that you were just making and the city's position. I am not a municipal law expert by any stretch of the imagination, but I see an item in the exhibits that is called a legislation details, and it has a recommendation by the department. I guess it's the Parks and Recreation Department, but then on the consent agenda in the minutes from the meeting is presentation, possible action, and discussion regarding the acquisition of 110.95 acres of land that will be developed into the community, West Side Community Park. And then on motion, upon a motion made by Council Member Benham and a second by Council Member Rectoric, the City Council voted 7-4 and none opposed to approve the consent agenda. If I was Ms. Somm and I saw this, I still don't know that I would know whether or not they had approved the purchase. Am I misreading municipal law in the way that I should be looking at that?
You have it, Chief, exactly right. Because of the language of that consent agenda. As you say, the minutes of the minutes of the September 11th meeting, all the City Council approved was an item proposing presentation, possible action, and discussion regarding the acquisition of Somm's land. The item neither proposed nor foretold that the contract would be approved. So I think you're exactly right. Even if she had been sitting in that room and watching the proceeding live, she wouldn't know by the consent agenda what happened to her contract. And then that goes to our other point. Even if sitting in that contract, she heard them approve specifically this contract, she still could have waited. She still would have known that the contract would not be enforceable until after the mayor executed. So she didn't have knowledge, but even if she did, the thing that made the contract, would have made the contract enforceable occurred days later. And in between the meeting and the mayor's signature, she revoked her consent to sell her land, which was her absolute power to do.
Justice Davis, you had a question.
Yes, sir. Back to what Justice Neal was talking about a while ago, counsel, in the substance of the real estate contract. Page 1, where it says, quote, such approval indicated by signature of buyer's representatives, plural, to this contract. The concerns that you've expressed today about mayor's signature notwithstanding, why isn't that language some indication when we look at the factual rendition? One or more city manager, and I think maybe somebody else, signed off before she made her position known about revocation. Mayor signs day later. Why isn't that some evidence that then goes to the concept of probable right of recovery for purposes of a temporary injunction that we're here on today?
Thank you for that question, Your Honor. And I think the answer, I have a couple answers to that. Number one, the execution in this document on page 8 was only by the mayor. If you look at the right before his signature is the phrase executed on this 11th day of September 2017. So the buyer's representative specifically signed there and then was attested to be the buyer's representative in the acknowledgement. But the second, I take your point, the representative word is listed plural. I think my reaction to that is every representative, if you consider the city manager a representative, it would have been sufficient, it would have been necessary but not sufficient to make the contract enforceable because all representatives needed to sign, including, which would be odd, maybe in some municipal contracts, the city secretary, including the assistant city manager, including the city attorney. Those were not necessary to bind in general municipal contract law. But here, both Jerry and the city said these are going to be conditions that must be met before the contract is enforceable.
Thank you.
And then finally, I was talking about delivery. I think you'll see in the briefing, they don't have any answer. They've never delivered the contract to SOM to this day, even after all this litigation. And so for all of these reasons, we ask that the court reverse the temporary injunction and remand, and I'll come back on rebuttal and answer any questions the court has.
Actually, I'm going to ask you to stay there and answer two additional questions that may give rise to more. But is there anything in the record that we can know from who wrote the date into the executed on blanks and why that person did it that way?
I don't think there's anything in the record that makes that clear, but I do want to say it doesn't matter. There's no legally significant attribute to that. The contract was made when the last necessary act for formation was done. And the condition preceding language that we've been talking about throughout our briefs postpones the effective date of an instrument until that condition is met. And so it doesn't matter. The September 11th date carries no significance at all, is our position.
Next question. I know this is probably one of the most difficult for an appellate advocate to address forthrightly, but I'm going to have to ask it. Let us assume that we might think there is a factual question that for the purposes of the temporary injunction, the trial court thought might go the city's way. And because of the limitation of the remedies in this case, the trial court might have thought that there was no other adequate remedy other than kind of putting this on hold until the merits are decided. And so we think if we got to the point where we thought there was a basis for it, the temporary injunction, although we questioned maybe whether or not that's what we would have done or whether or not the ultimate result is going to go with the city, how would we deal with that in this proceeding as the interlocutory appeal of a temporary injunction? And if you could try to address that, because I know it's antithetical to your arguments, but how would you approach it?
I think I'd approach it this way. And I know you're letting me stand on the arguments that I've already made. But one, we don't have to guess what was in the trial court's mind when the trial court signed the temporary injunction. The temporary injunction was based on the trial court's belief that the council's approval on September 11th was all that was necessary to enforce the contract. And I think on that ground alone, you can reverse. He didn't say that there's a fact issue. He's not talking about signatures. He's saying it doesn't, a city, the theory is that a city, once they utter an approval, the contract is enforceable right then and there, no matter what the terms of the agreement are with respect to signing. And I think the court could answer that question quite bluntly and say, this is not the law in Texas. On the second, had there been, I agree with the court, had there been a factual dispute, let's say that somebody at the city claimed that they overheard Jerry Sohn saying, I don't care about the mayor's signature. It doesn't matter to me whatsoever, and I waived that requirement. And Jerry Sohn says, no, I never said that. Well, that could be, because you can voluntarily relinquish a known right, to insist on that signature. But there's no evidence of that either. And so the basis of the temporary injunction was not some question about a factual dispute. It was a legal determination about what the impact of the council's approval was. And I can't find, and the council on the other side, at least to my knowledge, has not stated that there's any factual question about what the contract required in terms of signatures.
Okay. Thank you, counsel. You will have 5 minutes for rebuttal. At this time, we recognize Allison Killian on behalf of the City of College Station. Counsel, as soon as I get the timer reset, you may proceed.
Thank you, Your Honor, and may it please the court. This is a case about seller's remorse, plain and simple. Ms. Somm signed a real estate contract that the parties spent years negotiating. She sent the contract to the city. The several city officials signed the agreement. The city publicly pronounced in a city council meeting its intent to be bound to the terms of the agreement at a public city council meeting. And then Ms. Somm received an offer from somebody else for more money, and she tried to back out of the agreement. The city was forced to seek legal recourse and obtain a temporary injunction to stop her from selling the property to somebody else. And the trial court issued that temporary injunction to preserve the status quo until it could have a trial on the merits. Now, Ms. Somm admits to trying to sell the property to somebody else, and she has indicated throughout the litigation that she would prefer to sell it to somebody else. On appeal, it is her burden to establish that the trial court exceeded the bounds of reasonable discretion in ordering a temporary injunction. She didn't seek findings of fact and conclusions of law, and in a scenario like that, the court is tasked with looking at the record, and if there is any evidence in the record that could uphold a temporary injunction, then the court should uphold the temporary injunction.
So you would disagree with Counsel Jefferson that we can look to the order and see that the basis of his order is the determination that the city council's approval was all that was required, and that you would disagree that we are able to do that?
Yes, Your Honor. I believe this is in our brief. The city is in fact required to look at all of the evidence in the record and everything that was considered by the trial court in granting the temporary injunction. It is not confined to the four corners of the temporary injunction order itself. In fact, it must look at everything that was considered, including the resolution, the testimony, everything, not just what is in the temporary injunction order. The city has presented enough evidence to show a probable right to relief for breach of contract and asked this court to uphold the temporary injunction to ensure that the status quo is preserved until the lower court can hold a trial on the merits. Now, the only issue on appeal is whether the city accepted Ms. Somm's offer and formed an enforceable contract before she attempted to revoke. So the court is tasked with looking at a moment in time, namely September 13th, 2017, when she attempted to revoke, and ask itself whether, what are the legal obligations of each party to bind itself to this agreement? And did those things happen prior to September 13th, 2017? As we just heard, Ms. Somm's position is that she validly revoked because she attempted to do so before the mayor signed the contract. That argument doesn't hold up under the Clear Channel case, under the Petroleum Traders Corporation case, and even the Williams cases, where in the Williams case, the Supreme Court held that a group of ordinances were a valid enforceable contract once they were enacted by the city by public act. And here, the city accepted her offer in a public meeting on September 11, 2017. A number of city officials signed the contract before she attempted to revoke, including the city manager. And in fact, the city council approved the agreement before she even knew about the third party offer to buy her property. Now, the Texas Supreme Court in the Phillips case and in the Williams case recognized that to execute a contract doesn't mean to sign the contract. It means to bring it into its legally enforceable form. And, the city does not dispute that it always intended for the parties' legal obligations to arise from a fully executed agreement. And we have a fully executed agreement under these cases.
Do you disagree with the plaintiff that she could have required as a condition precedent the signature of the mayor?
Well, that's a difficult question to get into, and here's my answer to that. They could, if they took legislative action to give the mayor a authority to bind the city to contracts.
I'm not talking about making it binding. You obviously believe that the city council and the Williams and Phillips cases say that the contract is binding at the point that the council approves it. That's not what I'm talking about. I'm talking about, can Ms. Somm contract with the city in a manner that says, I don't care if I have a binding contract with the city, I want the mayor's signature on it before it is binding before it is enforceable.
Yes, thank you, Your Honor. My answer to that is no. They could only do that if they took legislative action to give the mayor authority to execute contracts on behalf of the city. There isn't any evidence of that.
You also disagree with the statement he made in argument that the seller could require the signature of Governor Abbott on the contract, and that the fact that he didn't sign it would nevertheless still make it a binding contract on the city of College Station.
I think the answer to that question is found in the Clear Channel case and in the Petroleum Traders Corporation cases. And in the Clear Channel case, the 14th Court of Appeals in 2007 held that a contract between the city of Houston and a billboard company was fully executed, despite the fact that the mayor didn't sign it and the charter required the mayor's signature when the contract was approved by city council. And in that case, a billboard company sent a contract to the city of Houston. The city of Houston approved the contract in a city council meeting. And prior to that date, an engineering consultant with the city of Houston had signed the contract. Once city council approved the contract, the city of Houston tried to back out and argued that the mayor's signature was required. The court said that a binding and enforceable contract was created by city council approval, and the fact that the mayor's signature was not there didn't matter. And then I believe a year later in the Petroleum Traders Corporation case, the Court of Appeals upheld that decision. And in that case, a fuel supplier sent a contract to the city of Houston to supply fuel. The city council again approved the contract. The mayor again did not sign the contract. And in this situation, nobody from the city of Houston had signed the contract. And the Court of Appeals said the signatures didn't matter. The public act of approving the contract in the city council bound the parties, and the contract was fully executed. Now,
that's talking about the binding nature of the contract. What if the contract in those cases specifically provided for signature by the mayor?
Right. So thank you for that question. I think, first of all, our contract doesn't require the mayor's signature. Nothing in the contract requires the mayor's signature. The word mayor appears nowhere in the body of the contract except in the signature area. His name doesn't appear anywhere in the contract except in the signature area. And Ms. Somm highlighted a portion of the contract where it states that every city official signed in their capacity as city officials. The mayor signed as the mayor. He doesn't have authority to execute a contract for the city. If the court finds that there's no probable right to relief because the mayor didn't sign the contract, that's assigning the mayor a power he doesn't have. And Ms. Somm doesn't provide any case law that says the city can confer authority like that on the mayor in a contract when the contract doesn't say that. The contract doesn't say the mayor has authority to bind the city to this contract. And
isn't that though the substance of one of the resolutions that was provided that the mayor had that authority. They were giving it to the city manager, but they weren't taking it away from the mayor, as I recall.
Right. Yes, thank you, Your Honor. So the resolution gives the authority that you're getting at to the city manager. There's no resolution giving that kind of authority to the mayor. What that resolution says is that there's nothing in this resolution that would conflict with that kind of power if the mayor has it. The mayor doesn't have it. The reason they put these kind of things in a resolution is likely so that in case the mayor ever has that authority, it doesn't have any effect on this resolution, and it doesn't have any effect on the mayor's, future power that we don't know about.
What would it take to give the mayor that power?
It could be found in the charter, and so the city would have to amend the charter. They have to make a legislative decision to amend the charter and give him that kind of power, or they could pass a resolution similar to this one. That there isn't anything like that here. The mayor's signature.
But they approved, if they approved, and that's a whole nother question, but if they approved this contract, the contract required the signature of the mayor. Why isn't that the same as a resolution?
Well, it's not a legislative act. Where there's a case that they cite in their brief that speaks to this. And it's a Supreme Court case, it's an older case, and it said that city council can delegate authority to the mayor, but it has to be by official action by a governing body, and it has to be express, and it has to appear in the minutes. The contract itself does not give the mayor any authority to bind the city. The contract requires city council approval. Such approval will be indicated by signatures of the buyer's representatives. The buyer's representatives are not defined in the contract. The buyer is the city of College Station, and the city, it has power to contract, but all the power of the city is vested in city council. By finding that a contract is unexecuted without the mayor's signature, that in essence is giving the mayor this power that he just doesn't have. And so the city would have to take some kind of legislative action again to amend the charter or pass a resolution of some kind. Yes.
Go back when you said a power he doesn't have. Why is his name even on here in the signature block?
Right.
Under buyer, City of College Station, by Carl Mooney, Mayor.
Right. And also the city secretary's signature is there as well.
As an attest, but the buyer says City of College Station by, and then a signature block for the mayor.
Right. Well, again, the contract was to be executed upon city council approval. City council approval was required. Such approval to be indicated, not required, indicated by the buyer's representatives. If the mayor, the city secretary, and anybody that signed the contract after the city council approved are to be considered the buyer's representatives, that's why their signatures are there. Nothing in the contract says this contract is not binding until the mayor signs it. What it says is the contract is not binding until city council approved. And again, in the Clear Channel case and in the Petroleum Traders Corporation case, in those cases, the mayor's signature was required by the charter. So while it's not stated in the case, I'm assuming there's a signature line for the mayor in there and it's empty. And the court in that case said that those contracts were fully executed upon city council approval.
But
I want to go back to where I was a while ago with opposing counsel. Page 1 of the real estate contract, quote, such approval indicated by signature of buyer's representatives. You touched on it just a minute ago to this contract. So we don't have a list here. We don't have an exhibit attached to the contract back when that says these 4 people have to sign off in their representative capacity before this is a valid contract. So as far as temporary injunction goes, shall we say, are you safe? Because this is some evidence of buyer's representatives that it's not exclusive to the mayor. It's a number of people could sign off. Or are we now tossed an ambiguity, but that because it's a temporary injunction case and we're only dealing with probable right of recovery, we don't have to go any deeper than that to try to determine what does buyer's representatives to this contract mean? Because you and the chief have just had a very healthy dialogue about, we got perhaps resolutions, we probably have ordinances, we could have. You just answered Justice Neal's question, headed that direction. So where are we? What do we do with that language in the real estate contract, page 1?
Thank you, Your Honor. I think the answer to that is what I referred to in the beginning regarding the standard of review here. And the cases say that the court should look at all of the evidence in the record and everything that was considered by the trial court. And if there is any evidence whatsoever that should uphold a temporary injunction, the temporary injunction should be upheld. I think there, when I look at this, it doesn't seem ambiguous to me. It requires city council approval. There's no dispute about city council approval. It happened. And such approval would be indicated by signature of the buyer's representatives. The trial court considered the fact that the city manager signed ahead of Ms. Som's attempted revocation, and the fact that there was a resolution that gave him authority to execute contracts after city council approval. The courts considered that, as well as the fact that the contract itself doesn't say that the mayor's signature is required before a binding contract exists. And again, the contract states that the city officials signed as in their capacities as city officials and nothing more. I'd like to touch briefly on the negotiations. So for 2 years, when the parties were negotiating, they exchanged letters of intent. And Ms. Som is a licensed Texas attorney. She should know that an ignorance of the law is no defense here. And in those letters of intent, the city doesn't dispute that it always intended for a fully executed contract to bind the parties. And we have that here, a fully executed contract under Clear Channel, under the Petroleum Traders Corporation case, and even under the Williams case, where the Supreme Court found that a group of ordinances duly enacted by the city that were never signed, and it even mentions signatures are not always required. What we need is mutual assent. And clearly, when the city enacted ordinances, they made known their intentions, and that was enough for the court.
Did the letters of intent, one or more, make it into the record for this case?
Yes, I believe they did. I'm not sure, Your Honor. I don't have it right in front of me, but I believe that they are in there.
All right, thank you.
And the purpose of a statement like that anyway, in a letter of intent, is to make known that the letters of intent themselves are not intended to be the contract, that the parties intended to reduce their agreement to a final agreement. And that's what happened here. The contract was approved in a city council meeting and was complete. And to further signify that September 11, 2017 was always the intended date of execution, that was filled in above the signature lines by the city secretary when she attested to the mayor's signature.
Just where I'm sure I understand this part of your argument, it is your argument that the city mayor's signature was not required for a fully executed contract, and that it is essentially irrelevant to this dispute.
That is correct.
Okay. Can we move to the question of delivery and how you argue that either it was delivered or that delivery doesn't matter?
Yes, Your Honor. The answer to that question is that delivery doesn't matter. In the Supreme Court case, I believe it was the Phillips case, says that, while signatures and delivery are evidence of mutual assent, they are not required to form binding agreements. That's a Supreme Court case. Generally, again, it's true that if they exist, we have delivery and signatures, we probably have an enforceable contract, but just because they're missing doesn't mean that there's not a binding agreement. And when we examine the policy behind a delivery factor, we imagine a scenario where I sign my name to a contract agreeing to buy a friend of mine's car, and I send that contract to him, and he opens it up in his house and he says, I accept, and he signs his name on it, and then he never, actually tells me about it. Well, when individuals are contracting, the requirements are a little bit different, or they're not really different, but they're just applied differently. The city cannot act in secret. Everything that it does has to be by public act. It has to happen in a public setting. It has to appear in the public record. And that's exactly what happened here. The city publicly made known that it was intending to purchase our property. It was binding itself to the terms of the contract. And if the roles were reversed and Ms. Somm was trying to enforce this contract against the city, certainly the city couldn't say, oh, well, she wasn't there. She didn't hear what we had to say at the meeting, and she didn't. So, that acceptance and delivery never happened. Well, of course, the city would be bound because it made known to the public, to the world, that it was approving the contract on that date. That's why cities have to act in public. And furthermore, it isn't practical to require cities to deliver contracts after public approval, because how would that work? Imagine the number of contracts that cities enter into on a given at a given meeting every month. So and those meetings are typically at night. Are those people, is the city intended to send somebody back to the office, call everybody who was subject to the contract and tell them what happened at a public meeting so that the contracts are fully enforceable on that date? I mean, that's just not practical, and it's simply not required by the law. Ms. Somm cites no cases where delivery was required after city council approved the contract. And the city has cited several cases that say that contracts were effective by public act. The Clear Channel case, the Petroleum Traders case, and the Williams cases.
Council, you said that they was binding itself to the contract by the action of the city council. You heard me earlier read the consent agenda item and the motion that was voted on. Can you explain to me why a person would know from that action that the contract, and I hate to ask it this way, but that the mayor was authorized to sign that contract?
You mean was not authorized?
No, was authorized. So according to your arguments, this somehow authorized the mayor to sign the contract. I assume, if he didn't authorize the mayor, but anyway, my point is, I read the consent agenda item 2M. I read the motion that was made, and I'm still looking for the agreement to a specific contract to purchase this property by the city.
Okay, so the consent agenda, when underneath the agenda, there was a link, and I believe you discussed this, to the legislation details, which went into great detail about what the terms of the contract were. It included a map, it had the property outlined, it had the price in it. And so anybody that saw that, and of course, Ms. Somm knew that the city was going to build a park there. She was well aware of all of these things. And, while that doesn't technically matter, her subjective knowledge in this scenario doesn't really matter, because what matters is that by public act, the city approved the consent agenda, which thereby approved the contract. I don't think there's any dispute that the city approved the contract in the city council meeting. So I hope that answers your question there. Now, regarding the city manager's signature, just very briefly, the trial court did consider the city manager's signature as more evidence that possibly the city had executed the contract prior to her attempted revocation. So that is something that the court should consider. Just very briefly, the statute of frauds. The statute of frauds is clearly satisfied because the statute just requires real estate agreements to be in writing and signed by the party to be charged. In this situation, the city is charging Ms. Somm with the contract, and her signature is not in dispute. She signed the contract.
Well, I think
Yeah.
they've raised a question of mutuality of obligation, and without the city's signature, isn't that mutuality missing? Old concept, but it's still viable.
Right. Well, not under the Clear Channel case or the Petroleum Traders case or the Williams case.
Now, in those cases, I seem to recall that there was a provision in one or more of the ordinances at issue that the city's mayor's signature, if it had not been signed within a certain number of days, then it was going to be, in effect, deemed signed or words to that effect. I'm assuming that the city of College Station doesn't have anything like that here, and would it matter?
Thank you. A, you're correct. The city doesn't have anything like that. The cases do mention that that there is a provision in the city of Houston's city charter that the mayor's signature is deemed to be on the contract, even if it wasn't. However, in this situation, I think that is analogous to how the mayor here testified that he had no choice. He had to sign the contract once city council approved it. It was like an automatic signature, basically. And that's a similar concept there. The signature in this case by the mayor is a ministerial act. It's not a required act. And I think that makes it somewhat similar to that provision in those cases. But again, in those cases, the court held that the signature was just inconsequential. They didn't find that the contract was formed 5 days later when the mayor's signature would have been there. They said that the contract was formed when city council approved. So I hope that answers your question, Your Honor. If there are no more questions, I'm going to quickly close. And I would like to remind the court that Ms. Somm has the burden here to establish that the lower court abused its discretion in granting the temporary injunction. She has presented no cases that say that a contract is unexecuted once city council approves it, but the mayor doesn't sign it. That is her entire position, and she has not presented any cases like that. The contract itself does not require the mayor's signature. Again, the word mayor doesn't appear in the body of the contract. We know the signature block is there so that the buyer's representatives can indicate that approval happened, but the date of that indication is not the date of execution. That the date of execution under Clear Channel and under Petroleum Traders Corporation and even under the Williams case is the date of city council approval. And if there are no more questions, this is going to complete my
I
argument.
just want a clarification. You just said that the mayor didn't sign. Actually, what we're dealing with, the mayor signed. The question is, did he sign timely under the facts in front of us, right?
Yes, I think,
There's no indication in the record that somebody signed the mayor's signature for him.
yes, Your Honor. I'm sorry if that was unclear.
Yeah.
Yes,
So the timeliness is the question, isn't it?
yes. So what I meant was, if you look at the date in question, which is
Yeah,
the
with the 11th.
attempted revocation, I'm sorry, the
and then
attempted
14th
revocation.
and the 13th, yes.
Yes. So if you look at it at the date of September 13th, there was no mayor's signature on that date. And so
Happened the next day, as far as we
Right.
know, right?
yes, there is no dispute that the mayor did sign the contract and that the city secretary attested to his signature.
Okay, thank you, counsel.
Okay, thank you.
At this time, we will hear 5 minutes of rebuttal from Mr. Wallace Jefferson on behalf of Jerry Somm. You may
Thank you,
proceed.
Your Honor. I just have a few quick points to make. On the resolution, which the court asked about, if you look at our tab 3, the resolution is there of the city council. And as the chief pointed out, here's what it reads with respect to the mayor. Okay, so it gives the city manager approval to sign contracts. And then in part 3, it says that the city council hereby finds that granting such authority to the city manager in no way precludes the mayor from executing contracts on behalf of the city when city council has approved such contracts if required by law, or as a condition of the contract. Here, our argument is it's a condition of the contract. The city argues that the mayor has no authority to bind the city. If you'll look on our reply brief at page 15, we quote the mayor's testimony in this respect that the city has not answered in any way. The question, you sign contracts on a regular basis for the city, do you not? Absolutely. And it would be typical fashion for you. Well, one, you get city council approval, right? It's absolutely necessary. And then the next step is for you to sign it, right? Correct. And when the city council gives you approval to a contract, you're executing the contract and agreeing and binding the city to the terms and the conditions of that contract. Do you understand that? The mayor says yes. Does that make sense to you? It does. I understand, but I mean, you wouldn't waste your time signing a contract that had already been revoked, would you? Answer, the council had authorized me to sign the contract, so I was obligated by council to sign the contract. So I think that shows the agent of the city in this case is the mayor by the resolution, by his own testimony, and by the contract itself. I would like to talk about the Clear Channel case quickly.
You're under
Chief, yes.
approval of the contract and what makes the contract binding on behalf of the city is a two-step process. City council votes and approves, and then mayor signs. And then without city council approval, the mayor's signature alone doesn't bind. And without the mayor's signature, city council approval alone doesn't bind.
That's correct.
Okay, thank you.
Yes. And we talked a lot about Clear Channel, the Clear Channel case. And Chief Justice Gray, you're absolutely right. And that's why that case is distinguished. There, the Houston's agent signed a purchase agreement for a billboard, and it was subject to council approval. Clear Channel, the billboard company, signed the agreement, and the city council approved the agreement. And then the city tried to back out some months later. The Supreme Court said, no, you can't back out. Why? Because the city's own resolution said that while the contract would not be binding unless the mayor signed, it also said that if the mayor did not sign within 5 days, then the contract would be binding. This is a concept that is familiar to lawyers. It's like overruling by operation of law, a motion for new trial. Trial court doesn't have to sign it. It's overruled by operation of law if the trial court doesn't sign. And here, the mayor's signature was not required if 5 days passed and he hadn't signed. That's the basis for both Clear Channel and the Phillips case that the council was talking about. The city has not said in her argument that there is any fact issue. I don't think there is any fact issue for the reasons that I said. And the basis of the trial court's ruling is in the trial court's order itself. There is no other basis that is mentioned at all. All of the cases that council have relied on to say that you can look to other aspects of the record are ones in which there are findings of fact and conclusions of law, and that brought the record in. In our case, there is only one ground that the trial court ruled on, and that was that the council had approved on September 11th, the contract. We've already talked about the approval doesn't mean that it was executed. In fact, the way the minutes read, you don't know what approval it meant. And so it was unclear at best. And at that time, the mayor had not signed. The revocation came before she signed. And then finally, I'd just like to, again, put this in the proper context. If I own land, if I owned 100 acres in Travis County, and I'm considering selling it to the city of Austin, and I've heard some city council members criticize me. I've heard the mayor may or may not have the authority to sign. I want the signatures to be in red ink because I love red. I can put all kinds of conditions on selling my property that I want. And the city then can come back and say, that is ridiculous, Mr. Jefferson. We will never agree to those terms. Or the city could say, if you want all city council members to sign, we want the property, we'll put that in the contract. We'll agree to those terms, and those terms will govern. Well, that's what happened here. Both parties said that before this contract is going to be enforceable, all these parties must sign, including the attestation, including a secretary, including an assistant city manager. It's not clear that those have to be done, but the party said, in our case, if we want to make this deal, this is what's going to happen. So this is not a question about the power, who has the power. It's a question about how do you interpret this contract? And does the offerer get to give the conditions that are required before she will assent to sell? And here, that is clear. And because it is clear, the injunction was unauthorized. And you have precluded somebody from freely disposing of their property now for years, which is antithetical to the way the law treats land and land ownership in Texas. And for those reasons, we pray that the court reverse the trial court's temporary injunction and remand for further proceedings. And we hope that the court will write an opinion that deals with the contractual situation that leads to enforceability or non-enforceability because revocation occurred before the contract was fully executed.
Thank you, counsel. Fellow judges, any further questions?
No, sir.
Were there any areas that you felt like we needed to ask for supplemental briefing?
No, sir.
Okay, counsel, this case is submitted and y'all are excused. Thank you for rolling with us as we began the unusual circumstances. We do appreciate your indulgence in the extra time that we extended to both of y'all, making excellent arguments, and we do appreciate it. Y'all are excused and this case is submitted. Thank you.
Both.
Thank you.
Thank you.
At this time, we're going to take a 5-minute break. Okay, is everybody ready?
Yes, sir.
Yes, Your Honor.
At this time, Mr. DuBose, and am I pronouncing that correctly?
Yes.
Okay. You have 22 minutes on behalf of Metropolitan, let me get my other set of briefs. Metropolitan Water Company, LLP, Metropolitan Water Company of Texas, LLC, and W. Scott Carlson. And you may proceed when ready. Thank you.
Thank you, Chief Justice, and may it please the court. I'd like to focus today on the overbreadth objections, which are the heart of this dispute, the overbreadth objections to these discovery requests. And to do that, it makes the most sense to me to break it down into two categories, a little bit different order from our briefs. The first category are requests that are not about payments to the Met Water defendant. These are requests 58, 59, and 62, and they concern payments to, contracts with, and documents relating to these leases about amounts owed by anyone. But the others are payments to and contracts with the Met Water defendant. And then the second category is, and I do that first category I think is the easiest, which is why I want to talk about it first. And then the second category is where the real heart of the dispute is, and that's the requests that relate to payments received by the Met Water defendants. So let's start with that other set of requests, which are the requests that are not about payments to the Met Water defendants. These are very broad requests. Number 50, and these are documents about the water leases. 58 is about all payments the Met Water defendants made to any third party over 16 years. 59 is all contracts with all third parties over 16 years. And 62 is all communications about payments not received by anyone. I mean, these could be payments to the Met Water that are owed to the Met Water defendants, or they could be payments owed by the Met Water defendants. And there's no time limit on number 62 at all. So the general principle for overbreadth, it's a little bit different from other kinds of discovery objections. Most discovery objections, it's the party resisting the discovery. It's their burden to prove the objection. With overbreadth, though, so much a burden, but the proof of persuasion rests on the party who's the proponent of the discovery. And the Texas Supreme Court talks about this in the In Re CSX case. The San Antonio Court of Appeals has a long discussion about it in Re American Power. And the party who's the proponent of the discovery must show two things. The first is a reasonable expectation of obtaining information that, secondly, will aid the resolution of the dispute. Now, on these three requests, 58, 59, and 62, the plaintiff's brief does not argue 58 and 59 at all. And its only arguments about request number 62 are about overbreadth. So we have no articulation in the briefs or in the trial court about what they hope to get from these three requests or why it might aid the resolution of the dispute. The first explanation we've received about that is the oral argument exhibit filed late yesterday afternoon. And it tries to offer some arguments for these. So let me just walk through those briefly. On request number 58, the exhibit argues, and that's the payments by Metwater defendants to third parties. The exhibit suggests that the purpose is to determine the amount of production on those leases. There are a number of problems with that. The first is that's not what the request says. The request is for all documents regarding payments by the Metwater defendant. Secondly, we have produced documents to show all production on these leases for all time. We have not limited what we've responded to by time. And what the plaintiffs want is everything else that also might show well, everything about payments, but I think in the hopes to get something else about production that would show the same or the information on the same leases. So there's a rule of procedure. It lies in the background of all this. We didn't cite it in our brief, and I think it's very important. It's rule 192.4, and that rule says the court should limit discovery if it is one of two things, either one of two things. First, if it's unreasonably cumulative or duplicative, or secondly, the information is obtained from some other source that is more convenient, less burdensome, or less expensive. And here we have provided this information already to show the amounts of production on all these leases. And it is overbroad to require us to go find every other document that talks about payments in the hopes that they might find something inconsistent.
Counsel, my recollection is that there was also, it was brought up in the initial response, or at least the amended response, that there was a claim for money had and received. And if I understand that theory, it is that the money that they gave you, gave your clients initially, they're entitled under that theory to trace it wherever it goes. And if they trace it to an asset that still exists and they prove that you took that money under one theory and used it for something else, whatever you paid for it, obviously I'm talking about your clients, whatever they paid for it, it's theirs. Because that's the theory of money had and received, is that if your client used it for some other purpose, whatever your client used it for, it belongs to them. So I understand some of where you're headed, but why isn't all of these, I guess you'd say, arguments gutted by the other claims that are in the petition that the plaintiffs have brought?
Right. So several things about that. If you look at the basic factual allegations in the petition, and they're all up front, and then you have after it, you have each of the 5 causes of action, which don't specify in fact. They just basically plead the cause of action. But if you look at the core of the complaint is only about 2 things. One is that the argument that the Metwater defendants have failed to make all the production payments promised in the letter agreement. And the second is that they failed to pay the portion of the reservation fees that the plaintiffs claim they're entitled to. And there's a dispute about that. But there's no, I don't see any factual allegation or anything else that alleges that somehow plaintiffs are entitled to amounts that the Met Water defendants paid to third parties. And, you know, if they had something more specific, but 16 years of all records of all payments to third parties seems to sweep far beyond a money having received.
Well, and I think that gets to their argument, and maybe now's the best time to go ahead and address it, of it was your burden to circumscribe this at the beginning, the pleadings, before you started resisting discovery about what is at issue, because what's at issue seems to be much broader than you are contending you need to respond to.
Well, I
What has
think,
been pleaded as being at issue. Now, whether or not you can be successful in circumscribing that, narrowing it, maybe getting some of the claims limited based on statute of limitations or summary judgment, this is what they argued in their response. But what I'm trying to figure out is that seems to be the first part of your argument, is that you have to jettison these other claims first and then talk about what's really at issue. And doesn't that just put it backwards? Don't we look at what's pled first? And now let's talk about the discovery on that, unless you are successful in narrowing the claims.
right. And I think you do start with what was pled first. And of course, there's a few other things too, and I'll talk about that later. But as far as to answer this question, you start with what's pled. And if you look at what's pled for all these causes of action, not just the contract claim, but for all these causes of action, the claim is that the plaintiffs were owed these production fees and a portion of reservation fees, and that they were not paid. And that is all. And that is the basis for the money had and received claim. It's the basis for the fraud claim. It's the basis for the breach of contract claim. And so, you know, in this exhibit that came in yesterday, there are a lot of points about matters that plaintiffs claim in dispute that aren't pled. And I think it's so important to start with the pleadings because they're not there. You know, issues about letting leases expire and that sort of thing. It is not in this pleading. Another problem this request, I think, is that the plaintiffs want, they want duplicative information because they don't trust Scott Carlson. And we've cited cases that say suspicion that a party has not complied with discovery is not enough to get overbroad information. There has to be evidence that the party has abused the discovery, and the In Re Masterflow case from the Texas Supreme Court deals with that issue. And I think the plaintiff's logic that even though you've produced, you know, the relevant information, we're entitled to everything else would allow them to get anything, any type of document. So request number 59 has the same set of problems. It's the contracts, all contracts the Met Water defendants have had with third parties. The plaintiffs argued that Carlson had manipulated payments among the different Met Water entities, but they don't explain what this request has to do with that, or why requests for contracts with all third parties is narrowly tailored to give them the information that they're requesting. And finally, in this set, number 62, communications about any unpaid amounts. And these are amounts unpaid by anyone, whether they're owed by the Met Water defendants or to the Met Water defendant. The plaintiffs claim in the exhibit that they are entitled to a portion of all amounts owed to the Met Water defendant. And I think there are two factors that are very important. The first is on the production payments. The letter agreement, unambiguous language of the letter agreement, which is Exhibit 1 to the response to the motion to compel, is that production payments are based on volume of production. They're not based on payments to the Met Water defendant. Now, there is a dispute about reservation fees and whether plaintiffs are entitled to those, but that wouldn't allow them to get this sweeping request that's not really related to that issue. Now, to address the second set of discovery requests, so these are requests 55 through 57 and interrogatory number 4, and they have to do with payments to the Metwater defendants. Now, let me say first what the Metwater defendants have produced. We have produced documents showing all production for all time, and we've produced checks for all time showing reservation fees received by Metwater LP. There are 3 disputes where the plaintiffs say this is not enough. The first is, are checks enough, checks and the documents showing production amounts, are those enough? Are plaintiffs entitled to duplicative discovery? And again, that gets to Rule 192.4. They're not entitled to duplicative discovery, discovery that's unreasonably duplicative or cumulative, or if there is other ways to get the information that is more convenient, less burdensome. And also, you have the distrust issue again. Plaintiffs don't trust Scott Carlson to give them the right documents, so they want all the documents, but that's not what the rules permit. And unless they can prove that there's been some abusive discovery, they're not entitled to those documents. Now, the next
law not an issue in that situation. I'm sorry, Mr. Carlson's history with the law is not an issue in that situation. That doesn't justify, in your opinion, the mistrust that would allow duplicative documents to be ordered to be produced?
Well, 2 reasons. One is that there's no evidence whatsoever. You have mere allegations by the plaintiffs of that in oral argument, and they have citations to the transcript, but it's the only thing you see in the transcript of the hearing was the argument of counsel. And I don't think, and I'm not going to get into it very far because it's outside the record, but I don't think the characterization is in that hearing is entirely accurate. But more importantly, the issue isn't whether someone has a criminal history. The issue under these cases like In re Masterflow, is whether the party has a history of abusing discovery in this case. And that's a very different matter from whether someone has a criminal history. Another dispute is, please.
Your argument that the discovery is duplicative and that therefore it's not, I don't know how to say it. You're not arguing that it's not relevant. You're not arguing that it is, should otherwise be produced, but it is simply that it is a different source of the same information. Am I understanding your argument correctly? And that you only get the second source if they prove that it was abused, there had been discovery abuse?
That's part. There's 2 parts. One is these requests sweep far beyond the category of what plaintiffs are now saying they hope to get. They're much broader than what they're saying they hope to get. But the second part is what you just said, is that a request is overbroad if it requests duplicative information that can be obtained more easily through other sources, including what's already been produced.
Okay.
And then this is one of the biggest issues, has to do with the reservation fees and whether the plaintiffs are entitled to documents about the reservation fees received by only Metwater LP or both Metwater LP and Metwater Texas. And this is an important point, and I just want to spend a little bit of time here. So what happened is the plaintiffs alleged that all the Metwater defendants have promised to pay reservation fees, and that is in the pleading. The ratification agreement, though, and that they're 6 different copies of the ratification agreement with different signature blocks, but they're all the same. They're attached as Exhibit 6 through 12 to the response to the motion to compel. Those agreements that address this issue do not mention Metwater LP. They only mention Metwater Texas. So to the extent that there is any obligation to pay these reservation fees, it would only be Metwater Texas and would not include Metwater LP. I may have gotten them reversed a few minutes ago, but it's only an obligation of Metwater Texas, and that's what we have produced. Now, as a general rule, the pleadings define the scope of discovery, and the plaintiffs are correct about that. But it is also limited by, courts look at 2 other things to limit the scope of discovery. One is the substantive law governing the plaintiff's claim, and the second is the plain language of the party's contract. Now, the substantive law, a good example of this is the later, we cite 2 In re National Lloyd's cases. The 2017 opinion goes into the substantive law about the standards for recovering attorney's fees at great length before the court says this is not relevant. So courts do look at the substantive law on issues like the alter ego issue here. Courts will look at the substantive law regardless of what a party has pled. And then secondly, courts also look at the unambiguous language of the contract where the discovery pertains to that contract to decide what is overbroad. And there's a good discussion of this in the case that the real parties cited. It's the In re American Home case from Texarkana in 2002. It recognizes that discovery about a contract provision would be improper if the provision is unambiguous and that discovery is what's sought is not at issue. And it discusses a case that we haven't cited, but it's very important on this issue, and that's the National Union versus CBI case, Chicago Bridge and Iron. That's 907 Southwest 2nd 517. It's a Texas Supreme Court case. And in that case, it wasn't a discovery case, it was a summary judgment case, but it pertained to the scope of permissible discovery. And what the court said is because an insurance policy was unambiguous, there were no factual issues meriting discovery. And so the Texarkana court in American Home said, if we had a contract and evidence, and if we could tell it was unambiguous, we would limit the discovery through this mandamus proceeding. But we will not limit the discovery in this mandamus proceeding because the contract was not in evidence at the discovery hearing. Here, the contracts, the ratification agreements were in evidence at the hearing, and they are unambiguous in that the only one of the Metwater parties they refer to is Metwater Texas and not Metwater LP. Just very briefly, the Metwater defendants the plaintiffs want other payments besides reservation fees and production payments. They say this, they want all payments received by the Metwater defendants because they don't trust Scott Carlson to categorize them correctly. Again, you're not allowed to go on a fishing expedition just because you don't believe a party has will comply with discovery without being able to prove that there's been no compliance. And I'll yield the rest of my time.
All 11 seconds. No, anything else before you hand it over to opposing counsel?
No, Your Honor.
Okay. Counselor Hobbs, on behalf of H&V Holdings Limited, and a host of other parties, including Hildebrand and Val individually. Let me reset my timer. Counselor, you may proceed when ready.
May it please the court. The scene that Mr. DeBose painted is not the canvas on which this court should base its decision this morning. Of course, my clients are suing to enforce agreements both written and oral agreements and seek production payments and reservation fees that Carlson promised to pay them. But the real heart of the lawsuit, unlike what Mr. DeVos says, the real heart of the lawsuit is that this group of investors were conned and continue to be conned by a man whose business model is essentially being a con man. He defrauded my clients and he continues to do so today. This is a fraud case. Now, this court can believe our story or not. It doesn't really matter. A jury will be charged with the elements of those claims that we have pleaded, including fraud, fraudulent inducement, fraudulent misrepresentation, conversion, pay money had and received. And the jury will decide whether we have proven what we believe to be true.
Counsel,
Yes, sir.
is Carlson a principal officer in both Metwater, Texas and Metwater LP in this record? Do we know that?
Yes, he is. And in our alter ego allocations, we do allege that he is using both of those companies as shell companies for his own personal benefit. That is in our pleadings.
And the record on this proceeding will support that.
Yes, and the pleading is attached to tab B of the bench book. And if you read those alter ego allegations, they are very broad that these entities are just part of his shell game about how he's moving money around to different entities and getting payments into and out of these shell companies in order for his personal benefit, which we believe in this case is to defraud us out of our money and our investment in these acreage.
Thank you.
I want to start with the scope of the request at issue, and this is really important because as I listen to Mr. DeBose talk about what these requests are, he makes it sound like it's all documents, all communications, all third parties, and it sounds overbroad if you listen to what he's saying. But if you read the request very carefully, every single one of those discovery requests, every single one, is limited to the acreage that the defendants purchased with our money. None of these requests have anything to do with deals that the defendants may have had outside of that acreage in Burleson and Milam counties. We invested in specific acreage and we expected transparency in return of that investment. We have no need to know what other shady dealings Mr. Carlson may have been involved in other areas outside of this specific acreage. It's not our goal. It's not necessary to prove our fraud claims and contract claims and other tort claims. But these requests, every single one of them is narrowly tailored to the specific acreage that defendants secured with our money.
Counsel, and that last phrase may have answered my question. The theory of money had and received that I was speaking with Mr. DeBose about in the scope of the related discovery, if you're not alleging that you're entitled to trace that money everywhere, then it's a different question. If he bought a house with your money, is it part of your pleadings that you are entitled to the house?
No, but he didn't. That wasn't what the contract was. The contract was you go secure these leases and we will get we are investing in it. And by the way, these payments roll out over time. We're investing millions of dollars for you to go purchase these leases in this specific acreage. And in return, we will get a percentage of what you get, what you receive, or what you're entitled to receive. We are entitled to a percentage of that based on our investment. Okay. And so, yes, money hadn't received. It's a very broad claim. It does.
But you're not saying we gave him $1 million and he paid 200 for, and I may be getting more into the trial court decision making here than the appellate, but you're not saying that you gave him $1 million, he paid $200,000 for the relevant leases, and he took our other $800,000 and squandered it. or did something else with it. You're only looking, you gave him $1 million, he bought these leases with it, and we're entitled to money as a result of that.
Right, and the fraud allocation, the fraud allegations, Chief Justice Gray, I think it's really important to remember. Our fraud allegations are that he promised us a percentage of everything he got, and now he's not. Now he's recategorizing payments, calling them reservation fees or production payments or take and pay payments or capacity payments. And he's using not only the way he's characterizing fees to deprive us of like our money that we are owed because of promises that he made to us, both oral and written. But then he's also using these entities as shell games. So he, is assigning rights and maybe bringing in money to one entity that is part of our investment that should be paid to us, regardless of what entity that money rolls into or when. And so that really is just the heart of the fraud claims too, and the misrepresentation claims that that we have brought and that we've pled, and that they have never filed any special exceptions. They've never moved for summary judgment to get a trial court determination of what fees we are entitled to. They never moved under 91A. These are broad pleadings, but not broad in the sense of, oh, we think because we have broad pleadings, we're entitled to broad discovery. These are notice pleadings. And that's all that we were required to do. And once they resisted discovery, we went to the trial court and we told them, look, this is what we've discovered so far through discovery, through other lawsuits that involve Mr. Carlson in the same trial court's courtroom. In fact, just before the hearing on our motion to compel in this case, the very same trial judge heard a TRO involving Mr. Carlson.
I need you to keep it within our record and what's in front of us. And to the extent that that record does include some other litigation or ultimately his conviction or whatever, as long as it gets into this record, we can use it. But right now I do need you to stay within I realize that may actually have happened where the trial court, because at one time we had a couple of other cases pending in this court related to other litigation that wound up getting transferred to another court of appeals. And this is the only one that's left in our court. And so I understand why it is very tempting to make reference to those, but
this is in the record, Chief, and I want to be clear here. In addition to our notice broad pleadings, which is all we're required to do on notice pleadings unless they specially accept to what we've pled, which they have not. The trial court was very aware both through our motion to compel that we filed and through the documents that we read to the judge of discovery that we've obtained in this case related to our allegations. Those were all before the trial court, and they're cited in the record cites to those items are all in our brief. It was very clear to this trial judge that this was a fraud claim, and that this was not just a breach of contract claim. It was very clear that our theories of fraud have to do with mischaracterizing of payments that Mr. Carlson is receiving as in an attempt to defraud us out of our money that we are entitled to, and that Mr. Carlson is using these entities as shell entities to move money around in order to get out of the obligations based on the promises that he has made to us as investors. And that is all before the trial court.
Okay, before you move on, is it 2016 is the date, the big date of when ratification agreement, one or more, I don't remember that right now, were entered into between some or all of your parties and the other side. Is that right?
That is correct, 2016.
Okay. What is the nature of the ratification process at that point, in the sense that, did that wind up, we can't use the word trump anymore, but it's a great word. Did that trump the prior contracts, one or more, that you would have otherwise been looking to? So therefore your discovery, I understand, lead to evidence as well as evidence itself. Are we really looking at a perimeter of ratification agreements on your behalf, and what arises out of that would be fraud and other things? Or do you go all the way back from the ratification to the agreements between these parties that were like 2002, 4, somewhere along in there? Are we to look at all of that when we're looking at what the trial court did here?
Yes,
My question make any sense to you?
it absolutely made sense. You're looking for the timeline. You might be asking me this question to see if the time frame of that was the discovery order was too broad. Let me start with the pleadings, and then I'll go to what I think is inherent in your question. And as to the pleadings, we have pled both breach of oral and written agreements. And we have laid out to the trial judge the theory on those. When we entered into these contracts in 2004, there were representations made to us at that moment, both to induce us to enter into that contract and to continue our investment. This was a continuing investment. Payments were being made, not like just one lump sum. They're being made periodically. And as the parties moved forward with the relationship, there were promises made to us. Those are our allegations. There were promises made to us about getting a percentage of all the all payments that were received, whether you want to call them production payments, reservation fees, take or pay. Mr. Carlson represented to our clients, our investors, that we were going to get a percentage of all of that. And that was before the trial court. We told this to, and that's within our broad notice pleadings as well. Now, I think why you are asking me that question is how far back does it go, is because.
My question was partially with the ratification process between the parties in 2016. What was knocked out as far as what is disputed going all the way back to 2004, or is it because of the tort claims that you take the position that not only are you dealing with however the relationship has gone forward since 2016, but you're going all the way back to 2004, and you believe you're entitled to do that as far as your discovery goes?
That's right. So we believe.
Is it both?
It is both. It is both. We do have a contract going back as far as 2004. We have pleaded that there were oral agreements made, email agreements made, and misrepresentations made going back as far as, the contract's 04. I think that the first, if you look through the discovery we have, and as we indicated to the trial court in the record, I think the first real disputes start in 2005. So it is going all the way back. But here's the thing, Justice Davis, like practically speaking, it's really not 16 years. Keep in mind, this pipeline wasn't even built until 2011. And if you look at the ratification agreements themselves, they say that the water didn't even flow through the pipeline until that point either. So practically speaking, it's not going back through all the way to 2004. The documents that would be relevant to this are going to be far less than 16 years worth of stuff. So
do they get triggered based on 2011 when water started flowing?
Well, we're not really sure. That's information that we would have if they weren't resisting this discovery. And please keep in mind, when they say that what they've produced to us, they have produced some information related to production fees, but they actually have offered to produce other information to us under a confidentiality agreement We sent them a confidentiality agreement to sign. They have not signed that confidentiality agreement. We do not have those documents. So I can't tell you for sure when Mr. Carlson started getting payments that we would claim we're entitled to. And that's precisely what this discovery is meant. We want to know what money Carlson received or is entitled to receive for the leases that he bought with our money. And that is in this specific acreage. And that is the limitation on all of that. That is the driving force for all of these requests. It's all limited to the acreage that he purchased with our money. And they are narrowly tailored to get that information. One analogy of on the time frame that you might be more familiar with instead of the water industry, Justice Davis, is just in the oil and gas industry. If I'm a landowner and I'm suing an oil and gas company saying I was entitled to royalty payments for this well, and I sued for an accounting on that well, the oil and gas company would be required to give me the financial accounting data for the life of that well. As long as it was producing and I was entitled to some of the royalties from that production, it doesn't matter if the well is a 5-year-old well or a good working 20-year-old well. There's just no bright line rule when you're dealing with the accounting. And here it's money hadn't received. We also sought the remedy of a constructive trust over all monies received. So we have both claims and remedies that are very akin to an accounting and oil and gas case. And I can't imagine an oil and gas company standing up here and telling me that I'm not entitled, as I represent a landowner, to know exactly what was produced from that well, what payments were made, what expenses were from that well. It's very analogous to that. And that's why the Chen case that we cite in our brief is so on point.
Refresh my memory while you're looking. Are
Yeah.
your collective group of real parties in interest, is that all investors or is that any of the landowners that actually did any leasing?
Well, we are representing mostly investors. And I use that term loosely, but that's a fair term for what they are. Some of the investors also happen to be landowners in the area. And that is why we know that Mr. Carlson has said he's made payments for the same acreage in the very same month for what should have been the same production amounts, to one of our clients who both wears a hat as a landowner and an investor. And the production amounts are completely different and the payment amounts are completely different. And so that is some of the ongoing discovery that we have gotten in this case that serves the basis and what we gave to the trial court is a rational reason about why we are entitled to this information about all payments received by Mr. Carlson or that he's entitled to receive for the leases bought with our money.
So is your lawsuit going to outline, for the benefit of us when we go back and look at your amended pleadings, who wore 2 hats and who wore 1 hat among your representative group of clients?
That is not in our pleadings because, again, that is notice pleading, but it was before the trial court in the hearing when we were explaining to the trial court why it is that we were looking for this specific information in this discovery request.
Okay, thank you.
The Chen case is which we cite on page 19 of our response, is a great case where a plaintiff sued an oil and gas company for obtaining lease covering minerals that the plaintiff claimed that she owed. And she sued for conversion, as we have here, and an accounting, which is much akin to our pleadings in this case, just not under the property code. And she wanted all accounting records, all payments made, any payments held in suspense related to the subject well. And the trial court compelled the oil and gas company to turn over the discovery requested, and it was affirmed by the Court of Appeals. And the court says plaintiffs are entitled to know what happened to their funds and whether any of the funds remain in Chen's possession. Because the documents requested by plaintiffs will provide the means for determining what happened to the proceeds attributable to their claimed interests, The documents are relevant to their conversion claims. So it's a great case on point.
I can hear the opposing counsel chomping at the bit to make this argument, but that was an oil and gas case. They get net royalty. It's after expenses. So therefore Chen is obviously entitled to the deductions, to know what the deductions from the gross sales from the well would be. Our contract is different. It is only a percentage of the sales. How are you going to answer that argument made by opposing counsel?
Well, Judge, that's because our case, unlike the Chen case, we do have fraud claims here. And that's really the heart of our case. And so we believe that we are entitled to a percentage of all the funds. We believe that part of the fraud that has happened in this case is Mr. Carlson is moving, he's renaming things, calling things something different than production payments or reservation payments. And he's assigning interest to those to different companies so that the money isn't flowing into the entity, and he can stick with his argument that this is a breach of contract case with a single Metwater entity and has nothing to do with the other Metwater entity. But that, I always am, anytime a defendant tries to mischaracterize the plaintiff's pleadings, you should really listen up, because what Mr. DuBose thinks is the core of our case, that's not up to him. The pleadings are as they are, and if he wanted to change the core of this case, he had ample opportunity. He sat on these requests for 14 months. So he had ample opportunity to narrow these pleadings down, as you alluded to in questioning him, Chief Justice Gray.
Well, I need to ask this one question before you leave the lectern and I get him back on rebuttal. Are you familiar with, and I'm sure you probably are, in Rule 52.11 of the TRAPS, groundless petition or misleading statement of or record, do you think we are at the point that the failure to recognize or address the breadth of your pleadings makes this petition to limit discovery borderline meritless or meritless?
Well, I have great,
I noticed in your oral argument that you didn't think it was needed because this was such a obvious answer that should be provided by the court.
Well, I do think, first of all, you and I both have so much respect, as everybody on this call does, for the Alexander DuBose firm. So certainly there's nothing that I would want to say that would disparage them or give them ill intent in what they did. I think they are being advocates, and it's in their advocacy hat that they want you to believe, and they wanted the trial court to believe, that this was a breach of contract case only, and that the only remedies we're seeking are these two narrow class of payments. And man, we'll give it to you, trust us, it's good, and that'll be done. And they have to do that as advocates, because once you realize the breadth of the claims at issue in this case and the remedies that we're seeking in this case, you have no choice but to say, yeah, I'm going through each of these discovery requests, and they're very limited, narrowly tailored to the specific acreage, and they relate directly to claims that we have that are live and that have not been narrowed down by any of the procedural methods for narrowing down claims.
Okay. I see your time has expired, but judges, she's only 2 minutes over her time. So if there's any questions, we got plenty of time.
I just want to make sure she has a wrap-up thought to give it to us. Other than that, I have no questions.
If you have a summary closing, we'll hear it now.
Thank you. I just want to real quick just address this idea that Mr. DuBose has raised about that we have some burden of proof that if there's duplicative requests that we only get discovery if we can show that they've abused discovery. In those cases that he cited, including one of them from the Houston that has like initials, MHBC or something, there was discovery abuse alleged in that case. But that doesn't mean that I can't ask, like interrogatory 4. Tell me the payment you made. I want to see it in an interrogatory. I want you to swear to what you've received with our money. And then 50, I'm getting my numbers a little mixed up here. 55 and 56 are just looking for the backup of that. That is traditional discovery. That happens every day in discovery all over. This is not an abuse of discretion for a judge to be like, that's right, answer the interrogatory and give them the information they need to verify what it is that you've answered the interrogatory with. That's not duplicative. That's just how discovery is conducted, even if we weren't dealing with somebody that we didn't trust, which we don't trust. But even if we weren't, the trial court was well within its discretion to order this very limited, narrowly tailored discovery.
Okay. Thank you, counsel. Judges, anything else for Ms. Hobbs?
Yes, sir.
Okay. Mr. DeBose, you have 5 minutes for rebuttal that will start as soon as I get the clock reset, and you may proceed when ready.
May it please the court, I think we need to start with the pleadings because that's been the big focus of this. And they are broad pleadings, but they only say certain things. And what we've heard from counsel is that there is a fraud claim, and that's what makes everything different, is this fraud claim, and it goes beyond these 2 types of payments. And I hate to read during oral argument, but I think it's so important to read what their pleading is on fraud. And this is paragraph 21 in the petition. Defendants represented that they would make certain production payments and reservation fee payments to plaintiffs. The representations made by defendants to plaintiffs were false, were material. The representations made by defendants to plaintiffs were false. When defendants made the representations to plaintiffs, they knew the representations were false. Defendants made such representations with an intent on plaintiffs to act on them, and then there's a discussion of damages. That pleading is limited to these 2 types of payments, which is exactly what we've said. Second point, counsel used repeatedly a phrase, what was before the trial court, which seems to suggest that there was some sort of evidence before the trial court. This is very important. The only evidence before the trial court, were the exhibits to our response to the motion to compel. The contracts, the affidavit of Mr. Carlson, and a few communications. We heard that what was before the trial court included a disputed information or contradictory information about production amounts. There was no evidence of that. It was only argument of counsel. Every citation in the real party's brief is to arguments of counsel with no evidence in that record. So I urge the court, if the court thinks that there is evidence with these, because there are these citations, to look at what's cited, and in every case, it is just the argument of counsel.
Counsel,
Please.
Rex, I'll defer to you first. Go ahead.
Well, thanks. This is housekeeping in a way, but did the trial judge in the motion to compel hearing, did he use or cite to any, take judicial notice of any of the other litigation pending in front of him among one or more of these parties? Did that
Not
come
that
up
I
in
remember,
the
Your Honor.
case? Sir?
Not that I remember.
Okay, thank you.
I was going to ask about sort of a related but issue on the evidence. I'm not a big fan of the cases, but there is a line of cases that talk about when argument of counsel constitutes evidence. Is that not going to be what we see when we go look at the record? Because it arose, as I recall, out of a Dallas Court of Appeals case in a discovery dispute, and has now been widely accepted that if counsel is making an argument about what the facts are or what the evidence is, that will constitute evidence, even though it's unsworn to, if the other party doesn't object. And is that what we're going to see, where counsel was representing to the trial court what the evidence would show?
I think you have in the transcript, basically, yes. The counsel is saying that there are, that we've seen some evidence that suggests this, but it's not in the record.
Okay.
I think that's correct. And then the final point is we hear over and over that the discovery the plaintiffs have propounded is narrowly tailored. I urge the court to look at this oral argument exhibit and compare what's in the actual request to what plaintiffs say they want on the right-hand column. And it's in each case, or not in each case, but for some of these, particularly the last three, the scope of the request is far broader. It is not narrowly tailored to what plaintiffs are claiming that they want. So we urge the court to grant the petition and vacate the order compelling this discovery.
We want to make sure we're all on the same page. You're referring to Ms. Hobbs' tender to us yesterday for today's use of oral argument exhibits. Is that right, sir?
That's correct.
That's what you're referencing when you say, look at those for comparison's sake. Is that right?
That's correct.
Okay, thank you.
Just as a housekeeping matter, I think one of y'all, I don't remember if it was you, Mr. DeBose, or Ms. Hobbs, during argument referenced a case that had not been cited in the briefs. If you did cite a case during the oral argument that it was not cited in your brief, there is an expectation. We used to have a local rule, but we repealed all of our local rules. But there is an expectation that you will provide us a supplemental brief that contains those citations and how they might have been used. We used to do it by Friday. If you'll do it by a week from today, I'll be happy with that. And then judges, is there anything else before we close?
No, sir.
All right. Thank y'all very much. Appreciate the arguments. This case is submitted and you all are excused. This first session of the 10th Court of Appeals that sits in Waco, Texas, being held via Zoom, is now officially closed, and we thank y'all for y'all's participation. Y'all have a good day.
Thank you, Judge.